Uh, Todd asks, are there any definitive differences regarding injury liabilities in Missouri and Illinois and Missouri? Absolutely, Todd. Good question. This is shooting from the hip, but I'm going to give you my top 10 differences between Illinois and Missouri in liability laws. Number one, Illinois has a 2-year statute of limitations to file a lawsuit for injury claims. Missouri has a 5-year statute for general negligence, a 2-year statute for medical malpractice, and a 3-year statute for wrongful death. Difference number two, in Illinois, in a wrongful death claim, the jury instruction allows for damages for grief and bereavement and the sorrow for losing a loved one. Missouri law does not. The damage instructions in Missouri versus Illinois are different, and the damages awarded in both those states are different as well. Number three, Missouri has caps on non-economic damages in medical malpractice cases, which is always around $740,000. So if you are paralyzed for the rest of your life and you go and try, and the jury gives you $10 million for that, the judge will reduce that and for the non-economic damages portion only. You get your economic damage, you get wage loss damage, you get medical expenses past in the future, but the non-economic damages, meaning the pain and suffering, disability, disfigurement damages, those are capped in Missouri through tort reform. So those are three differences. Let me go to difference number four. In Illinois, both states have comparative fault, meaning if you're in a car wreck or slip and fall or something like that, both sides, the plaintiff can be assessed fault. If in Illinois, if the plaintiff is more than 50% at fault, they don't recover. In Missouri, it's pure comparative fault. So if the plaintiff is 95% fault, they still recover for those damages. Let me go to, am I either on 4 or 5? Let me go to number 5. In medical malpractice cases, Illinois has a statute that says that a lawyer has to cap his attorney's fee at 30%, and Missouri does not. So remember that if you're a plaintiff in Illinois, your lawyer should only be charging you 30% a contingency fee. In Missouri, we charge higher, a little bit higher than that. Number 5 or 6, I lost count. So let's just say I'm 6 because I'm running out of ideas. In Missouri and Illinois, both of them have what I call lien reduction statutes. And what that means is that when you have medical bills in a case, and the medical bill providers make a sort of lien in the injury case to get paid out of that case. In Missouri, it's very strong law in Missouri. So in some ways, Illinois law is better in injury cases, and sometimes in Missouri they're better. But the lien reduction statute in Missouri, the medical providers are allowed to get a certain percentage of the recovery after attorney's fees and expenses. The plaintiff gets half the money, and the lien providers split the other half of the money on a pro rata or even basis. And then they can never sue or go after the plaintiff again. So it's a complete bar to any further recovery. In Illinois, that's not the case. In Illinois, you do have the lien reduction statute where the liens are reduced and whatnot, but the lien provider can still go sue the client later for the balance of the medical bill. So in Illinois, we always try to get full lien reductions and agreements with the providers so our clients are not pursued that way. We take a very aggressive stance at reducing medical liens in cases regardless of whether they're in Illinois or Missouri. 7, at trial, when you're putting in evidence of medical expenses in Illinois, you get the full value of the medical expenses, meaning that if the hospital charged $50,000 for medical expenses, the jury gets that $50,000 bill and that number. In Missouri, they don't. In Missouri, through some tort reform that was passed, in Missouri, the jury is only entitled to hear the number that was paid to satisfy that bill, meaning that if the person had health insurance and there was a $50,000 bill and the health insurance paid 20 grand of it and there's no remaining balance, the jury only hears $20,000. So the person only receives, so the plaintiff only receives, would likely only be awarded $20,000 in those damages. Here's my next difference in Illinois and Missouri. I'm either on 7 or 8 now. In a premises liability case, the law is a little bit different when it comes to snow and ice. So in Missouri, it's a new, if there's a dangerous condition on property, it's a knew or could have known standard, meaning did the landowner, the homeowner knew or could have known about this? It's a little broader. In Illinois, it's a knew or should have known standard. So should the person have known? And then, the other differences let me give you 2 more differences in Illinois and Missouri. In Missouri, when you're going and getting medical records and that kind of stuff, there's a statute where you can get an affidavit from the medical provider, and then that all comes into evidence, which is great. In Illinois, they don't have that. So in Illinois, a lot of times when we're gearing up for trial, if the other side wants to be jerks, they're going to say, oh, you can't get any of your medical records and bills, and you have to go take subpoenaed records depositions of the providers. So then we issue all these subpoenas, and then we have to go take these depots, and it's a little bit of a pain. It's our job. We don't mind doing it. We're not above it or anything. But then what typically happens in Illinois is the other side will stipulate to that, or we will do a request for admission. So, but I have had lawyers who have said, you got to go do this. And we go issue a bunch of subpoenas and we're getting ready for trial. And then when they see we're about to go take all these depositions, they stipulate and say, all right, we won't mess with you on that. And then, there's different rules in Illinois and Missouri about disclosure of experts. Illinois, the expert disclosure is more transparent. In Missouri, you really don't have to say much. You tell them what the general nature of the opinion is of your expert, and then the other side has to go depose them. In Illinois, under 201K and some other rules, the expert disclosure is more robust and more transparent, which is actually better, frankly. The expert standard for whether or not in Illinois or Missouri a person can get on the stand and testify is different in both states too. Illinois is a little bit more liberal. Missouri had tort reform and established and adopted the Daubert standard for the submission of expert testimony as well. So those are 10 differences between Illinois and Missouri law. Sorry to pontificate or do it, but I'm shooting from the hip. And there's some other ones too, some other good ones. Let me look at the list of questions here I got.